what they were signing up to be obligated for their citizens. And so it's really led to a lot of important conversations and realization of not just the right to equal recognition before the law for people with disabilities in those countries, but also the right to equal recognition before the law is really key to a host of other rights. You cannot realize most of the other rights in the CRPD without realizing Article 12. And so it's really essential that states now have this framework. They have the Committee on the Rights of the Person with Disabilities, interpretation of it. There's a lot more understanding. And with that comes a real desire and need for supported decision-making models. And that's where, I guess when we get to present, we'll really talk about how things are falling short. But I guess I'm the woman representative. So I will just say Article 15 of the Convention on Elimination of Discrimination Against Women also includes the right to equal recognition before the law. And the combination of those two has really led to the changes in the last 10, 20 years that have led to women with disabilities being able to realize these rights to which they were historically denied.
Do other folks kind of want to jump on that and draw more connections to kind of women's capacity as well as capacity in the disability context?
Could I just maybe not necessarily on that point, but if I think that I'm already envisaging that my function on this panel will be to be devil's advocate. So I think that, I mean, just in response to Charles and Joseph, I mean, and partly because this is all my scholarship has been fairly skeptical about the CRPD in many respects. Not in principle, not in the fact, not in what Article 12 says, and not in the aspiration, but in some of the articulation of how we're meant to interpret Article 12, for example. So the England and Wales and the UK is a signature, obviously has ratified the CRPD. However, they refuse to recognize the GC1, the general comment number 1 on Article 12. So, but I think that from my own perspective, I wouldn't necessarily say that the MCA or the Mental Capacity Act in England and Wales or this kind of capacity legislation in and of itself is intrinsically backward, because I think that what you are seeing in at least at a domestic level on the jurisdiction is that there is quite a lot of development in terms of trying to empower individuals with impairment, also implementing mechanisms around supported decision making. However, there is a sense in which there's a real disagreement about whether there is a place for substituted decision making and the breadth of obligations that are owed to people with disabilities. And that's one of the things I think is the main demarcation between capacity legislation in England and Wales and perhaps things that are happening in Ireland and other jurisdictions. But anyways, sorry, I didn't answer your question, Jessica.
Yeah, maybe I know that Katie and I haven't necessarily heard all of the conversation, but if there's anything that you wanted to contribute on this kind of first set of questions about the past, how things have changed over time in terms of capacity and consent, feel free to jump in.
I don't know if anybody's spoken to adolescents in the way that human rights law looks at adolescent capacity and consent. If not, I could say a little bit about that. Can you hear me? Am I very loud?
They are. But very accessible, so well done. I don't think she said anything.
Oh, sorry. Are we? I couldn't hear you guys. Are we okay? Should I do that?
We can hear you just slightly.
It's okay. Why don't you continue the conversation and then we'll come back to folks on Zoom, I think, so we don't interrupt the flow.
We got you.
Oh, wonderful. Oh, I was just saying, I don't know if anybody's spoken to the way that human rights law looks at adolescent capacity and consent, but maybe I could provide a bit of framing around that if that's helpful.
That's great. Yeah, we haven't talked about that yet.
Wonderful. I was just going to note that, you know, the Convention on the Rights of the Child is a bit unique in that it recognizes explicitly that adolescents have evolving capacities, and that the capacity of children and adolescents evolves over the course of their childhood as they progressively acquire different competencies, understanding, and increasing levels of agency to take responsibility and exercise their rights. But at the same time, the Convention on the Rights of the Child also recognizes the right to special measures of protection. And I think these are often seen as sort of in juxtaposition to one another, where, you know, both the right to the ability to exercise your rights on one hand, but also your right to have special measures of protection to make sure as a minor that you're not put in a position of exercising rights that you don't actually have the ability to exercise. But in the context, at least, of sexual and reproductive health and rights, these two things have been interpreted by the Committee on the Rights of the Child to actually be really in coherence with one another. And they recognized, in fact, that where adolescents are unable to exercise their sexual and reproductive health and rights, or where they're unable to access reproductive health care, that actually is a violation of the right to special measures of protection. So I think it's an interesting bridging of this sort of two sides of the coin around autonomy and then also the evolving capacities piece of the framework.
Maya, did you want to jump in? Again, apologies that we haven't had you here for the full initial conversation.
No worries about that. I was going to say about disabled children and how the right to legal capacity can be recognized based on the CRPD, and provided that they do have a right to be heard based on the CRC, and how this has been evolved over the years throughout these CRC committee's decisions and concluding observations and homework, especially based on the CRPD committee's development on the right to legal capacity and how it can be distinguished from mental capacity. I do agree with what Katie said, and that's a very challenging issue, how this can be balanced, how children's rights to legal capacity can be balanced in the framework of their evolving capacities, and how we can understand that. But I do think there has been a lot of progress in that field.
Let's see. Did we talk at all about kind of older persons in capacity? Do we want to talk about a little bit?
I mean, you know, so I can just say that the chief way in which I think human rights law currently deals with older persons and capacities is through the CRPD, and that we don't have an older persons specific convention, though groups have been talking about it for over a decade. And I think one of the big challenges in terms of implementing CRPD is that, of course, it was the language of Article 12 derived, you know, from significant input from the communities of folks with IDD and psychosocial disabilities, but folks with progressive cognitive decline were not really involved in the drafting of Article 12. And I think as a consequence, there's been sort of this ill-fitting effort to figure out how exactly Article 12 can be implemented for folks with dementia and Alzheimer's and other forms of progressive cognitive decline, because the model doesn't exactly fit. So I think the rights at stake are very similar and are the same, but the implementation, I think, kind of hasn't been figured out yet. And people are working on thinking about, you know, for example, how could we pilot supported decision-making in the context of folks experiencing dementia? People are starting to try to do that, but the roots of the practice aren't from that world in the same way. And so it's proven to be difficult.
A great transition for us into the question of implementation. So what kinds of challenges have we been seeing in terms of implementing these evolving standards around capacity and consent? And also, you know, are there any kind of like good examples, you know, like best practices in terms of what the states are doing?
Well, I think we could say that since the UN Convention opened for signature, there has been a global program of law reform throughout the world across lots of different areas as state parties try to bring their domestic law into compliance with international human rights standards. And I don't think it's very clear that no country is fully compliant with what the UN CRPD is requiring around universal legal capacity, supported decision-making. And also, I suppose, as well, allied to this debate, the really contentious debate is around the interpretation of Article 14 on the right to liberty to abolish mental health laws because they're discriminatory, and that there's been a big backlash to this as well. And I should say as well, you know, the UN Convention on the Rights of Persons with Disabilities, it espouses the human rights model. It challenges the medical model of disability, which situates the issue within the person with the disability, and they're a person to be, you know, to be cured. And it's a really powerful critique of law and policy. So I don't think any country in terms of legal capacity reform has got there. I'll talk a little bit about the Irish legislation, which is seeking to move in that direction. Now, we in Ireland, we have ratified the convention, and when we did ratify it, we were the last EU member state to do that in 2018. So we knew what we were ratifying, and there was reservations in around Articles 12 and 14. But there has been a bona fide, I think it's fair to say, attempt to try and move closer. So the Law Reform Commission in Ireland published a report in 2008, which recommended a piece of legislation very similar to the Mental Capacity Act 2005 in England. And in Amnesty International, where I was working at the time, we were campaigning a lot around the Mental Health Act, which we wanted to see reformed to better respect the rights of people, particularly involuntarily detained and treated. And we started campaigning then on the capacity legislation because there was a massive, obviously, crossover. And there was a really interesting person advising a former academic in the Minister for Justice, who was very critical of mental health legislation, and he became very interested. And as a result, that 2008 bill was abandoned. And there was a bill that was published in 2008, and then eventually another bill was published in 2013, which became the Assisted Decision-Making Capacity Act 2015. So it doesn't move fully to comply with the UN Disability Convention in that it does retain substitute decision-making, so somebody can make a decision for somebody if they're deemed not to have capacity to make a decision. But what it does importantly is that it brings in other layers of support, so it provides for decision-making assistance. So people can assist a person to make a decision. They retain their ability to make legally effective decisions. You also have co-decision making, and then you also have advanced healthcare directives. And so you have a number of different mechanisms to try and support the person to make decisions. But there is a functional model there as well, retained in the legislation. So it's certainly not fully compliant. But I should say as well around assessing capacity under the legislation, it doesn't say who assesses it. It doesn't have to be a medical professional that assesses. It could be a range of people that assesses capacity. And it isn't a medical assessment. It is to see in terms of the person making the decision, understanding information, retaining information, weighing up information and communicating it. And there's a real premium placed on engaging with the person and supporting them to make decisions. So while it's certainly not in Ireland compliant with the convention, it only commenced last year. So even though the legislation was published in 2015, it took a long time. There was a regulator set up to try and regulate and safeguarding, and there's lots of issues with it. So we don't really have a sense yet of how it's working in practice. But I think it does demonstrate the importance of international human rights, particularly for a small open economy like Ireland. We're very susceptible to international criticism. We try to comply with human rights standards. And we're trying to move in the direction of recognizing universal legal capacity and providing support. But it remains to be seen whether it's going to be effective in actually achieving that.
Just to ask for the folks on Zoom, if you could speak close to the microphone. So did anyone else want to jump in? Let's go for it.
I fear that I might answer not a question that you asked, but I maybe in answering the question about implementation, I would be more inclined to answer a question about the challenges around implementation, and you'll see the direction of my research in the kind of things that I'm concerned about, because one thing that I thought was really apt in as a description of what the general comment was meant to do in number one, what general GC1, what it was meant to do in around Article 12. Mary Donnelly had said this, it was about just shifting the Overton window, because our notions of disability are so here. And then the GC1 was so much further along there that somehow then you end up in the middle here and you're shifting the Overton window. And I thought that was one of the best articulations of what this space is. But I see that a number of real challenges around implementation. The first is that is the rights-based model and the autonomy-based focus. And I wonder about the traction that it has with divergent conceptual schemas. And so I think about it in the context of, for example, in different spiritual views, or in African personhood, or in how there is a different model of the person and the person as situated within the community, and how disability and the function of disability in these conceptual schemas. So that there is a kind of gulf between the aspirations and the rights-based articulation of what the CRPD is meant to do, and what people believe and what actually has resonance. And so I think that that's one of the things that is a real ongoing challenge as to how much this international human rights approach can really speak to these different divergent conceptual schemas.
So Britney Spears, I never thought I never thought my career would have so much to do with Britney Spears, which is really like central to everything, which I'm very pleased about. But I think here's my concern about this dialogue that happens at this very rarefied level, and what is happening in courts and with families on the ground. I think capacity is often used as a way, a pretextual way to get an outcome that we think is appropriate. And for people with IDD, I think those are very much based in concerns about paternalism, about, you know, the need to protect, the need to ensure that they do not engage in behaviors that might compromise their ability to live. With the dialogue is not about self-independence and autonomy, and you know, we, as you said, Camilla, really focus on the idea of independence versus interdependence. And so, and that's very central to our rights-based framework as well. I mean, if you look at the Americans with Disabilities Act, it's a piece of legislation that really focuses on plaintiffs, individuals coming forward to say that they have been discriminated against. And so you need to be able to access that system. And so you were talking about other schemas, including spiritual ones, like disability justice is another way that, you know, disability communities, and what is a disability community? I understand these are freighted words, like what is a community? Certainly Britney supporters are a community, you know, but I think, you know, disability justice starts from that space that says that if you have Patty Byrne, who was actually the director of a dance group called Sin's Invalid, which is a troupe that really focuses on people who live at the intersection of disability, race, gender, and sexuality. So these 10 principles are kind of articulated by Sin's Invalid and by Patty Byrne and Mia Mingus, a few other, you know, luminaries in that space. And they really focus on how to provide access to people who don't necessarily, who might have rights in name, but cannot really substantially access them. It focuses on how to build community and how to build capacity to maybe take care of some of these things. We have Article 82 of the Mental Hygiene Law, which is now focused on supported decision making. It's still a system that's only accessible by certain people who might have those support systems in place, who might be able to access that system and engage with that system. Whereas if we move out of that and we look at community support, if we don't have to validate the systems of decision-making that we have in place in order to retain decision-making capacity, this provides a framework for doing that. Now, I know I haven't said anything about the principles themselves, one of which is interdependence, one of which is leadership of the most impacted, so not looking at it from the perspective of the people who can be reasonably accommodated in the language of the ADA, but really looking at the people who need unreasonable accommodations, right? So I think there is a disconnect, and I think this is a very simple point that I've taken a really circuitous way to come back to, but I think capacity is capacious. Like, it's an idea that we often use and abuse, and I don't think that what happens on the ground in courts, with families, in hospitals, in terms of city policies, we've now seen policies that seek to criminalize people with disabilities who live, unhoused people with disabilities. The whole system is not built around this idea of capacity, and that is where the disconnect is. That's where I'm seeing a problem. And maybe the disability justice, one of the things we're doing, people with disabilities have their children removed from them at these incredibly high rates. Like, I think it's something shocking, like 60% of people with IDD will have their children removed from them at some point in time. That might be higher. And so something our clinic does is we do a lot of family defense work, and we've actually shifted so that we're not focusing so much on defense in court, which we do, that there's a space for that. But also we have something called a doula project, which is where doula is someone who supports a birthing person. And a lot of the times children are removed at that point when they're in the hospital. So parents with disabilities never really, usually IDD, never get a chance to actually parent because of misconceptions about parenting. And our goal, and we're a legal clinic, a litigation-based clinic, but we're trying to do something that engages the community a little bit more. And so we're trying to get doulas in place to subsidize doula services for parents with disabilities, people who are going to give birth and people postpartum, just as a way of having one more advocate in the room to see if we can divert them altogether from the legal system. And so maybe what this means is that rights-based dialogue has some limited utility, and we maybe need to be thinking more creatively about how we, think about capacity.
So I just want to sort of echo 2 points. One is we do live in 2 very different worlds. We're here talking about the right to legal capacity. If you went, 60 blocks downtown to the Supreme Court of the state of New York, and you were before a guardianship judge in the general court, they probably never even heard those terms before. So we really have a lot of work to do to bring this right home. And, we've started to make little inroads, but I really think there's there's the world of the advocates and the human rights world. And then the court system here still has not absorbed any of these changes in a really significant way. The other thing I just want to echo is one of the shortcomings, I think, of the movement here around, trying to at least pass supported decision-making legislation is that it still really is this privatized individual thing where, we have now 20 plus states that have laws that recognize supported decision-making agreements where you can put down on paper, people you trust to assist you in making decisions, and you can sort of spell out the type of support that you'd like. But of course, that's all contingent on you having those people in your life already. So we've sort of privatized this idea of support, which is not what the convention starts with. The convention starts with the obligation of states parties to provide the support that people with disabilities may need to exercise their right to legal capacity. So we've done this, you know, classically American thing of making it a private right if you can afford it.
You can manage
Or
it.
if you can manage it,
Yeah.
yeah, and that's really a problem, you know, I understand as a strategy and tactic why we had to start somewhere, and, you know, hopefully we can build upon where we've started, but I think in the long run, it will really circumscribe who can benefit from this right that we've, you know, that we're attempting to implement.
And sorry, station. Just to kind of say that, you know, when they are state provided services, that can sometimes act against you when it comes to showing that you have capacity, because the more it depends on the quality of those services. And we're coming out of a period of, you know, I feel like we run our supports for people with IDD and psychiatric disabilities, and our supports medical system is like on this austerity measure. We're always stripping money away from it. We're always on the knife edge of not having funding. And it shows, right? So people have had to make arguments that someone had support because they had services from the Office for People with Developmental Disabilities in New York. Including someone to take them out into the community to help them with the money management. So they, you know, don't necessarily need someone to do their finances with them, you know, to manage their finances. They have someone to help them with making medical decisions, and they go to a day program. But the quality of these services is poor. And that is a very easy argument to make. You know, that services are transitional, they are, the people who provide them are not well paid and may not necessarily be able to stay there. So what is the worth of these arguments then? You know, and so that's something that is very frustrating as an advocate, but no doubt for my clients.
Yeah, from our perspective, you know, I just to emphasize the point that I think there's a lot of discussion of kind of what it should look like from a legal perspective, how the you know, the legislation should be drafted or changed in each country, but ultimately what it does come down to is oftentimes most of these deprivations of legal capacity occur in informal settings and require the attention and this framework that responds to the need of the individuals with disabilities who are experiencing those deprivations in informal ways. And a lot of the communities we work in and do research in, which isn't in North America or the global North. And there is a different schema of decision-making and community-based decision-making and recognition. But I will tell you, I've talked about these topics in all across the world, and the problems are fundamentally the same. And I can speak with some authority to this, is that so I have a brother with an intellectual disability. We have a supported decision-making structure in place for him. And I think in a lot of other communities, he would be a candidate for guardianship on paper. And he is lucky to live in British Columbia that has one of the best, I think, supported decision-making structures and options in place. And it doesn't matter where you go in the world, there's always a disconnect in practice between kind of the way the medical services, because we do a lot of work in sexual and reproductive health and rights and denial of legal capacity in those settings, and perception. It doesn't matter what is on the books, but the perception of the medical field and the family members it takes a humongous amount of work and change and value shifting to enable someone to be able to make a decision whether they legally can or not. And that has real consequences, from forced sterilization to forced contraception to forced abortion to, you know, not providing informed consent to procedures when giving birth, to not providing informed consent to, you know, giving your child up for adoption. But what it comes down to is that capacity strengthening and support at all the different levels. From, you know, for us, our orientation is the individuals' disabilities themselves, and ensuring that they have that recognition and understanding of the conception of individual decision-making. Because for many people with IDD, it doesn't really matter what community they are from. They have never been given the opportunity or the chance to make decisions. And so the default is not making decisions, even if you are in a community that doesn't have an institutionalized system, which many countries do, and then you're even in more trouble to be able to make decisions. But so starting with the individuals, so we have a program we developed with the UN Reproductive Health Agency on a curriculum for people with disabilities to know their rights related to sexual and reproductive health and rights, including a specific module on informed consent that enables people to kind of practice being in a medical setting and advocating for their rights. But a key piece of what we've done for many years with UNFPA is that capacity strengthening with medical service providers and shifting that value system of seeing people with disabilities as being able to make the decisions for themselves. And then just to emphasize again that family members will, as a parent now, they will always see their children as a child, and you add an intellectual developmental disability into the mix. Even for my parents are both in this field, and they still, the idea of sex education for my brother who's 25, makes them squirm. And yet that is essential. And yet it's something we don't have very good models for, and we really lack the empowerment of the individuals themselves who can speak up for themselves, who really can change, I think, a lot of these conversations for the better and can shift a lot of the conversation because they can speak for themselves. And even within my last point being that even within the disability community, as we've been giving this curriculum, which includes this module, there's still a lot of belief in the broader disability community that people with ID and DD cannot make decisions, and they are the one exception to equal decision making. And so there's a lot of work for us to do within the disability community, even to ensure that they're part of the solution for ensuring that people with ID and DD and psychosocial disabilities, I should say, are not denied that key right.
For folks on the Zoom want to contribute?
Yeah, I think maybe just to build on the comments that were just made, I think that just to sort of maybe a point of clarification. So my work is around adolescents generally. And so I think in thinking about implementation, one thing that comes to my mind is the Committee on the Rights of the Child has been clear that for access to sexual and reproductive health services that are preventative and time sensitive, that there should be a presumption of capacity for adolescents who are seeking those services. But I have not done an exhaustive review. I cannot think of a jurisdiction that has adopted that as sort of the way that they approach adolescents' access to sexual and reproductive health services. Writ large, we see where there are explicit ages, they tend to be relatively high, and even in those cases where there's explicit ages, where they recognize that adolescents can access services, that still means there's a host of adolescents who might need them, who require parental consent to access care. But I think to the point that was just made is that people can't even seek that care if they don't have information about what their sexual and reproductive health needs are without an environment that provides access to comprehensive sexuality education. I think it's just impractical to imagine people who think it's likely that they might be turned away from receiving care, or that their parents might be notified, especially in smaller communities where you're looking at a community-based provider. That they would then be able to seek out those services feels just pretty unrealistic, especially when you sort of attach the stigma to sexual and reproductive health and rights as well. So I would just elevate those pieces too.
Naya, I understand difficulties. Are you able to hear us, and do you want to jump in?
Hi, can you hear me?
Yes.
I'm sorry, I lost most of the conversation for that part.
No worries. We're still on the kind of present, any sort of challenges to implementation or best practices that you want to highlight. If you have any thoughts on that.
Oh, so I was just thinking that the biggest challenge when it comes to disabled children is to understand how they can exercise their legal capacity and how there can be a balance between the problematic principles that underpin the Convention on the Rights of the Child, such as the best interest principle and what lies beneath the assessments, based on that principle. And the way the CRPD committee has interpreted the right to live capacity as being a distinct concept from mental capacity, and how children's mental capacity is still being assessed in that framework. So I think there are many challenges there that need to be identified and dealt with to understand how to better implement this right and when to seek children's consent.
Just, you had said you also wanted best practices, so, and I'd be curious if any of the other panelists have thoughts on, but, you know, you have had countries like Colombia and Peru and Argentina and Costa Rica to a certain extent that have more or less abolished guardianship and frameworks such as that, but really from what we hear on the ground from advocates it is that implementation problem again, and the lack of supported decision-making models that are realistic and practical for usage in the communities as to what you do once you've abolished a system that enables people. Because, and I think Priyanka and I used to both work at Disability Rights New York, and I think we saw this repeatedly. Guardianship is efficient, right? Like you can make a decision for someone versus, I mean, we do all we can with part of what we're doing right now is research on legal capacity with researchers who are themselves people with intellectual and psychosocial disabilities. And so all of the research materials we're developing together have to be accessible, and we're using supported decision-making for those attending the support spoken. It is the opposite of efficient, but that is part of the process. And it's also part of the process when you're fixing, you know, things that have not been developed, and we don't get funding for transferring. It's hard to get funding for translating stuff into easy read or simplified language, or have timelines that account for the time it takes the self-advocates to process, get support people to support them in a setting like that. And so we need better solutions for what that implementation can look like in considering what people's lives are really like.
And I think part of the problem is how we conceive of disability, right? It's always been conceived of as being about productivity. Can you contribute to the economy in any meaningful way? If you can, then you're entitled to do certain things, right? You're entitled to have children because you can support them. You're entitled to parent the way that you want, because being part of this society means that if you can earn money, you or can earn your worth, then you are entitled to do certain things. And we've also had this history of institutionalization. And so capacity is tied up with that. You know, it has been tied up with the idea of someone making all your decisions for you because you were in an institution and your life was run with this kind of bell ringing precision that somebody else dictated what you did. To the point, so for us, and guardianship, issues of capacity, very much tied up with assets, and they always have been from like the Norman Conquest onwards, you know, and the treatment of people with IDD differently to people with psychiatric disabilities, you know, the idea that the king could act as regent over the assets of someone with a psychiatric disability, but would hold things in trust for them versus someone with an IDD where they really could take over their estate and manage it as they wished. These ideas of disability, IDDs specifically, being permanent and never changing. And so our ideas of capacity, we don't think about it as something that's evolving. You either have it in this moment or you don't. And that is just not how people work. You know, we've had guardianship cases over young people who cannot manage their finances. But I ask you, find me an 18-year-old who can manage their finances, right? Like, that's not a thing. People who have made bad relationship decisions. All right, you know, I mean, that's a lot of us would be under guardianship if that was the mandate. So it's a real case of proving you have capacity. That's where approaching it from a different angle on the ground to what's happening internationally. And anyway, I'm very angry.
Yeah.
Charles wanted to jump in and then, yes.
No, you
No,
could
you-
do-
No, I just wanted to say that, I mean, because I completely take your point and I agree with you. And in fact, a lot of the points about having informal, non-legal mechanisms is so critical, because I think one of the things that has come up time and time again about implementation is about the sort of legal safeguards that must be in place for the oversight. And to me, this sounds like just further juridification of people's lives in this space. And that cannot be the solution. But just the other point is just that there is a case that you're talking about guardianship, but it is the case that some capacity legislation, and I'm very critical of the MCA as well, please believe me, but there is the case that in the legislation, there is why the MCA has been seen to be progressive is because of the idea that you start with a presumption of capacity. And one of the cardinal principles is also that an unwise decision is not coextensive with lacking capacity. So I would say that there's a spectrum of legislation in this space that seems to be progressive or moving in the right direction, potentially. Yeah.
Just that we also have in the new Irish legislation, it's explicit in Article 3 of the Act, or Section 3 of the Act, that unwise decisions doesn't lead to loss of decision-making ability. But just to talk about some of those challenges, I actually think really Article 8 is very important on awareness raising under the UN Disability Convention to disabuse people of those prejudicial notions. And similarly, for the first time in international human rights law, there is a right of access to justice. And in Article 13, there is an obligation on the state to ensure appropriate training. So coming back to your point about the training of judges here in New York in relation to university capacity, I think there's a lot of work that needs to be done there in terms of addressing paternalism. And in the Irish legislation, we saw it as a big win, that we were able to push back on the best interest principle, which we saw it should be now removed when the new bill comes in on the mental health legislation to align it. But we saw really some terrible decisions in Ireland where the High Court basically absolved psychiatrists for not complying with the legislation around detention on the basis of the paternalistic intent of the legislation, because the general principle was around best interest. So that is why that's really important to say that, you know, the committee has been very clear that best interest isn't an appropriate concept for adults, and that's why you don't see it anywhere in the convention in respect of adults, and that's why it shouldn't be in legislation, because it leads to that kind of erosion of rights, in my view.
Anyone else want to jump in?
Yeah, I just have one more small point. With regard to the challenges, so I don't think we can underestimate the level of paternalism and also the power of this notion of protection. Because to the extent we have these, you know, somewhat enlightened or more enlightened guardianship laws on the books, there's this assumption embedded in them, which is that the guardianship will actually protect someone. And it's an assumption that we see, you know, certainly the Britney Spears case showed you serve no protective function, but even in cases where a guardian isn't abusive, it's not actually clear that the guardianship is serving a protective purpose. And so, you know, I just think that is something that we still have to sort of refute. I mean, even the model law in the US is called Uniform Conservatorship, Guardianship and Protected Persons Act. So it's just permeates every discussion in this area that the guardianship will serve a protective function, and it's the default way of protecting someone, as opposed to maybe a once in a very rare, you know, situation way of protecting someone. So I just think we can't underestimate the power of that concept.
So I think at this point, we've already started, but moving towards thinking about the future, how do we think that the law around this should develop? what kind of strategies for implementation do we think would work well moving forward? Any thoughts on that?
Well, I could start with my outlandish views that will just already set the tone with the much more reasonable views that will come out. So I think that in the first instance, and it follows on with your point, perhaps, but I led a project called the Judging Values Project, and we looked at the values of legal professionals who are operating in the court of protection and are effectively representing individuals under the Mental Capacity Act when they come to cases, come to the courts. And the reality is that the values that operate in this space are far more nuanced than a simple binary between autonomy and paternalism, or autonomy versus protection. And this is something that I think that in order to make progress in this space, I think that that binary really we have to try to move away from, because in some ways it is not capturing also some of the subtle ways that even best interest decision-making, for example, try to honor the shape of a person's life, even as they make a decision, a substituted decision on behalf of somebody. And so, for example, you see a lot of best interest decisions, not all of them, but some of them that are incredibly careful in thinking about the holistic assessment of the person's life and their relationships. And then the second point, I think, has eluded me, but yeah, it may not. But I think that my point is that it's really important to think about how we, my second point, now I remember, sorry, and I'll stop, but is the other thing that I think we need to move away from is a focus on the deliberative moment, because we focus so much about this choice and that and capacity for this moment. But the reality on the ground is about how there are so many judgments that are being and evaluations that are being made when you care for somebody or when you are involved in someone's life and supporting them, that is not just about that deliberative moment and honoring them in that deliberative moment, but our focus in law is so much preoccupied by this. And so my kind of skeptical view is whether, you know, we need to actually move away in these two ways to make real progress in this space. But yeah.
Sorry.
I have two thoughts. The first is that I don't know about the utility of this idea of capacity. I'm not sure that it's really serving the communities that we're trying to work with. And so one idea that I have, which is maybe more outlandish, is like, let's do away with it. It is not beneficial to us. It locates the problem in the body or in the mind of the individual at the center of that discussion. It is not about, if we are talking about police brutality, guardianship is not going to assist with that. Issues of capacity are not going to assist with that. If we are talking about, and a lot of guardians want guardianship because they feel like this is how they can protect their child from getting an adult child from getting into a situation where they're going to be confronted by law enforcement in this country. Sexuality and disability, again, the question is, will the individual be abused or neglected if they're living in an institution, and it's unclear to me what guardianship can really do to resolve that problem there. Going off exactly what Rebecca was saying, guardianship does not provide protections for some of these things that families believe it's going to be useful for. And so the question is, do we focus on the capacity of the individual, or do we just think of understand their vulnerabilities because of the social position that they're in? So we don't pay home health aid workers enough, That's the problem. That's why we don't have community supports, not because the individual lacks the capacity to make independent decisions. Like, we've got to be flipping things around a little bit more. The second idea that I have is one about reparations that I've been writing about. The idea of disability reparations. Like, I think about in New York, I think in the United States, the guardianship is enacted under the state's parents patriae power, right? It's this this power that the state has to take care of its citizens. It's meant to be benevolent, it's meant to be kind, it's meant to be protective. And yet, and a lot of the more progressive legislation is written that way, with the aim of having, you know, the court check in and make sure that the guardianship continues to be necessary. Practically speaking, the unified court system is overburdened and unable to do that. That's really fallen by the wayside. It's not something that happens. And so you have cases like Britney Spears, who, quite frankly, is like the paradigm of someone who would probably easily get out of a guardianship and yet found it so difficult. We don't gather data on this, but we know that people who are under guardianship tend to be poorer, and they also tend to be more elderly. They're not Britney Spears, and they certainly don't have her following or her capital. I mean, it's really strange when you see bipartisan support for something these days, and she united everyone. But the idea that it's not just about the removal of the guardianship, it's about the pain that was caused in that period. So if you have been prevented from exercising your sexual and reproductive rights, she wanted to have a baby, because the guardian exercises medical decision-making powers, they prevented her from being able to remove her IUD. Are you not effectively sterilizing the individual in that case, especially if it goes on to the point where the person is no longer able to have children? So there are harms that come out of this system of capacity that need to be redressed. And it's not simply by removing or stopping guardianship. The conversation is not about, well, now you have capacity. It's you were harmed when nobody checked in periodically about how your capacity to do something, to approach a problem, changed. And given that we've located the problem in your body, and that we've located the oversight to be the responsibility of the state, failure to do that has to result in some kind of compensation, I think. And then maybe we'd be more careful about whether or not we put guardianship in place. So I see it as a tool towards abolition as well.
Question? What's your thoughts on this?
I could just say, Article 19 of the UN Convention on the Rights of Persons with Disabilities is a right to live in the community and to be included in the community. And throughout the world, people with disabilities are at greater risk of living in institutions or in congregated settings or social care homes. And I think that's a real barrier. I think the use of state resources to let people make choices over where they live, how they receive support, direct payments, they're all very important things to create an environment where people can be in the community and develop their own network of supports. I think that's very important. So I think there has to be kind of a radical shift across lots of areas. And then I know obviously how states invest in social services changes from country to country, but there are things that are very important as well to create an environment where people can make legally effective decisions and live in places they want to. I sit on the Human Rights Committee for a large disability service provider, and we've moved away from kind of an institutional model to kind of people living in homes in the community, but really they're kind of like, in some ways, very often mini institutions with institutional practices operating there on a smaller basis. And people have a restricted access to clothing, food, because a doctor says you can't smoke, you're not allowed to smoke anymore, or you get 6 cigarettes a day. Those kind of institutional practices deny legal capacity and how people want to live their lives. So I think it's really important that people have choice about where they live and who they live with. And that's very important for having a very meaningful life with control over your life.
Sorry, I think I'd be good at this by now. Yeah, I just wanted to emphasize that I think in order to really Anka spoke to the disability justice principles, and that's very much something that guides our work. And in order to address this issue moving forward, there needs to be more attention paid to the intersectional, particularly for us, the gender perspective of how the stereotypes relating to women and the particularly a protectionist view, and what is protection is different for women than it and gender diverse people than it is for men with disabilities, and that the manifestations of both the denial of legal capacity, the scope of those guardianships, the decisions that are deemed to be good decisions best within the best interest of the person are very much guided by a view of what a role is for women, and which is why so much of our work sent in legal capacity intersects with sexual and reproductive health and rights and gender-based violence, because those are two forums in which it very much often comes up for women and gender diverse people with disabilities, because of guardianships and guardianship systems, and the denial of legal capacity intersects very strongly. And we do have decent research to show that it intersects with the higher rates of gender-based violence against women and people with disabilities, and that if you're under guardianship, you are more likely to experience and have experienced violence for a longer period, because there quite literally is no way to get out of it. Priyanka and I were involved in a case of someone being abused by their guardian, and it was such a learning experience as a young attorney, because the judge just looked at us and was like, yeah, but I don't really want to harm the mother-daughter relationship by removing her as guardian. And it was just so shocking that that would be the priority in this situation, as opposed to removing the guardian. Like he felt it was a set that his job ultimately was to maintain the relationship as a form of protection rather than remove the guardianship. And that, I think that had a lot to do with, it was a mother-daughter relationship. And that's why, especially when it comes to forced abortion, forced contraception, you have cases where someone is, rather than having the violence they experience being referred to the police, the desire is to put a guardianship in place for those protection mechanisms. And that's generally recognized as a good use of guardianship, rather than what it is, which is just another form of violation by removing the autonomy from the individual. So looking at those intersections is really essential to being able to address and unpack the problem, and also, as we develop supported decision-making procedures that are effective, that they need to be effective, recognizing all those intersections that are at play too, race, religion, ethnicity, and what is deemed to be a good decision, and in who's making the decision of what is a good decision there. So, at Women Enabled International, we're in the process of doing research in 5 different countries, as I mentioned earlier, focused on the legal capacity related experiences of women and gender diverse people with disabilities in the sexual reproductive health and rights setting. So we've been piloting this inclusive methodology with Inclusion International and TCI, Transforming Inclusion for Communities, on inclusive research. But the focus groups are being done, and they're almost finished, in Spain, Uganda, Fiji, and they're going to take place next week in the US, in Ohio. And what we are seeing from that research is, the informal, in particular, denial of legal capacity is rampant throughout all of those countries, even though they all have very different legal capacity frameworks and very different regulatory systems. The similar issues and the intersection with the higher rates of violence in all of those settings is very much cross-cutting across all that research. So from there, we will have recommendations that are developed by the focus group participants and the self-advocate researchers. So keep an eye out for that in June 2025. I'm happy to follow along at womenenabled.com org if you'd like to find the research when it comes out, but we're hoping that will provide a useful data point for these conversations for the future.
Katie, do you want to jump in, or you can also open it up for questions?
Maybe just to lift up this piece on accountability, which I think is really important as we think about accountability for decision makers who are making decisions that, I think as was just said, are based on gender stereotypes or disability stereotypes, and just thinking about the different pathways for accountability and the way that those do or do not exist, and even where they do exist, who's actually able to access them.
Does anyone have a question for our speakers?
So I've been really fortunate to work on, with Together Scotland, in the UK, to work to adopt the UNCRC. And through that work, I also published a child-friendly version because I saw an issue with access to the information that we were publishing in a larger policy brief. And I also had the ability to work on the status person with disabilities report, which also has the issue of accessibility in terms of different languages like that. So I know that you guys talked about the challenges, you talked about some possible solutions, but are there any concrete kind of steps forward of the accessibility issue within both the CRC and the CRPD in terms of, you know, are the people with disabilities getting the access to the legal information, these constant updates and these constant reformings for the legal protection for themselves as well as for the children?
Well, just to say, what's really important about the UN Convention on the Rights of Persons with Disabilities is that it has requirements around accommodation. So under access to justice, that civil and criminal, there is an obligation to provide whatever. It isn't subject to reasonable accommodation. It's subject to there's no restriction on the obligation on the state in terms of the monetary cost, but there's an at-large obligation to provide accommodation so that people can be participating meaningfully in legal processes, including proceedings in relation to decision-making capacity. Similarly, in relation to children, there's an obligation as well to meaningfully engage with them. In general comment number 1, there's some interesting comments there from the committee trying to really move, I suppose, the jurisprudence on the best interest of the child more towards placing obligation on the states in their domestic laws to ensure that they're meaningfully engaging with children, even though there isn't the same equivalence, I suppose, in relation to recognizing will and preference of the child. But certainly the committee is pushing more towards involving children and providing accommodation for meaningful engagement. And I can say from the Irish legislation, it has been very impactful because in the legislation, there is a specific statutory obligation to provide information in a format that is accessible, and also that a person doesn't have to communicate in the ordinary sense, however they communicate, that is sufficient to engage in the process around determining what supports they need, or whether or not they have capacity to make a decision. They might need a substitute decision maker. So I think that's why the UN Disability Convention is very important. There was a real invisibility of disabled people before the convention. Of course, the whole nature of human rights is that they're universal, but there was a real invisibility issue around disabled people, and that's why the convention is very important around accommodations and accessibility.
Thank you all so much for speaking today. I wanted to know how you approach the rising issue of physicians on suicide. In the disability justice space, there's been a lot of discussion about whether physician-assisted suicide can be truly their own free will, especially considering the social and political pressures that people, especially people with disabilities, can be under while they're working through that choice and that option if it's available to them. And so I wanted to get a sense of how you all approach that issue, as both this question of whether that's an option that should be available to people with disabilities or people generally, in terms of autonomy and in terms of
To take that one.
Camilla.
Well, it's a live issue, absolutely, in the UK right now with the private members bill, and it's very interesting because we've had disability advocates arguing how dangerous this legislation is, and also pointing to various jurisdictions where you see a sort of slippery slope developing. But then Tom Shakespeare, which is he's one of the leading disability scholars in this space, he just headed a letter that was basically saying that he argued in favor for this bill, saying that it wasn't actually necessarily harmful to people with disabilities or intrinsically discriminatory or focused on this idea about the what is it, whether a life is worthwhile, you know, how do you determine that threshold? I don't think I can give you a definitive answer, but I do think that the dangers are very, very present, because if we think about how often coercion comes into this space, and particularly about where support has, and when support actually becomes coercion or becomes some kind of undue influence, it's always tricky, given the fact that if you think about somebody needing support and is particularly vulnerable based on their embodiment or based on their needs, that they might be more susceptible to the influence of others. So I think that it is quite, you know, those things have to be balanced. I don't think there's a right answer, and I think you're wanting a right answer or a definitive answer. But I for myself, I don't think that there is a right answer, but there is a sense in which what chimes with one's values in terms of whether you value this idea about having a good death and having choices around that, or whether there is a sense in which you think about the givenness of life and death as well. And I think this is the higher order question, even beyond the disability worry.
I mean, I haven't fully thought this through, so pardon me, but I feel like there is no denying a reality where disabled lives are not valued, right? This is the system that we live in, where even, you know, during COVID, there were all these triage protocols that sought to take ventilators away from people who needed them with disabilities to give to other people, because in New York, because of their lives were just not seen as being viable. So in that triage system, they were at the bottom of that chain. So it's a real concern that disability advocates raise. That being said, I feel like sometimes there is a false alliance between people who campaign against abortion and physician-assisted suicide on the basis that that devalues the lives of people with disabilities, and therefore that's the basis for not permitting abortion or physician-assisted suicide. But they're not really grounded in what disability communities might really want. And I think we have to be careful. We have to be careful about uncoupling that, because there may be people with disabilities who very, very reasonably want those options. And I think we have to be very careful about denying those opportunities.
We haven't done any work on this. We have a thing at Women Enabled called the Disability Culture Club, where we once a month learn about an important issue and think about how we need to include in our work. And we recently had one on assisted suicide, particularly how it's playing out in Canada. And I think one of the things that really resonated with us and has a key intersection with our work around care work is that a lot of the research that has come out, particularly in countries like Canada and the MAID legislation there, which is very extensive with the assisted suicide. And now the research that can be done on looking back at the people who have made the decision is a lot of the people with disabilities who have chosen assisted suicide. There's data that shows that they made that decision because of the lack of support services and care in their communities. And I think that is very much the concern, and where the attention gets diverted and investment gets diverted from the supports, the attention, the framework, the decision-making. I think it's naive to think that the conversation of the decision-making and legal guardianship could not be perverted with the decision-making of those are related. They will be related, and there will be cases that show they are related, and that you have to also consider for women with disabilities, you know, what is a full life, what is a meaningful life is very much tied to your reproductive, homemaking, abilities, and for women with disabilities, who don't want to do that, that is a consideration in the decision of whether their lives have meaning. And so it's not an issue, but we're dealing with at the moment, but it's definitely, as you pointed out, a issue that's becoming more and more important to the community, and is one that we're all thinking about.
We have time for one more question. Let's have a question for each other. Oh, there's a question over there.
But as someone new to the idea of supportive birth systems in the UK, I'm wondering, how do you prevent it from sliding into guardianship, where people kind of using the window dressing assisted decision making to actually be making decisions for people, especially when the person who's being assisted has barriers to communicating their desires.
It's a great final question.
Yeah. I mean, that's a major concern. That's a major concern. In New York, there was a model that developed here where both the decision maker and the supporters had to go through what they call a facilitation process, which was, somewhat lengthy, involved set of meetings to sort of make sure everyone involved understood their role, including the supporters. And it was thought that provided some kind of, at least it set the stage in a way that hopefully would have long-lasting impact on the relationship. In states where you can just sort of sign an agreement and that process doesn't take place, I think we don't fully know exactly what's going on. On the other hand, I would say that just like there's this possibility with supported decision-making, there's the same possibility with powers of attorney and with guardianship. And so anytime you have decision-making, there is this possibility of abuse and someone taking over in a way that goes beyond what they're supposed to be doing. And I think we just don't really know enough yet to know the extent to which it's happening. I do think that whether it's a facilitation process or some kind of training, there was a bill in Massachusetts that proposed training before entering a supported decision-making agreement. I think sometimes that could help. On the other hand, I'm very mindful of the concern of over legislating all these informal relationships, which I think is a real concern. So I don't really have an answer. I can just tell you how some places have tried to deal with that concern.
So, I mean, this is not a legal answer. So, but I would say that that's why it's so critical to attend to. I mean, I would obviously say that the philosophy behind this, but to think about the interpretive conditions of that interaction. So actually thinking about how one is interpreting various things about embodied interactions, about verbal tics, about what are those interpretive conditions and in that engagement. And that's, I think, is so critical to think about, because we tend to think about all the kind of formal mechanisms, but in fact what facilitates and fosters support is really around about how well you actually are interpretively engaging with that individual. And that's where the stakes are high, really, is to think about, well, how am I actually engaging with this individual, and what are my presuppositions that are informing my engagement at the very beginning? Because we all start with some certain presuppositions. So I think it is the kind of hard ethical graft that is required at a deeper level, that really it goes beyond the law. That's why this space is hard, and that's why it goes into the realm of ethics. It's precisely because it involves a kind of human element and a human interaction that we have to cultivate in our character.
have a couple of ideas. The first is that the state, no, the first is that for someone within that relationship, the important thing, supported decision-making, substituted decision-making, both of them, is the ability for that individual to actually seek the termination of that relationship. We've got to make that easier. If we're operating within this system, we've got to make that easier. It's really difficult if you're under guardianship to have that guardianship removed. It takes a long time. You need access to an attorney usually. You know, it's only very recently that there's some resources even available on the New York court website that are geared at a person with a disability petitioning the court to have their guardianship removed. You want a guardian, there are lots of forms that you can just fill out, you know, just do it yourself. We don't have that. So the ability to uncouple from those relationships, I feel like Gwyneth Paltrow, conscious uncoupling, but no, the ability to kind of extract yourself from those relationships, we've got to make that easier. That's one way to mitigate that problem. The second is that we continue to require oversight, even in these relationships. There is no way, we don't want to legislate too much in that space, but in these informal relationships, you might have people being, and it happens under guardianship, that protective measure, sterilized without their consent. You know, where they're even actively concerned about it, just in collusion between the medical service provider and the guardian. And entities like the protection and advocacy system for each state, which is like the entity that's been developed to intervene and provide supports and services and advocate for people with disabilities in those states, have intervened to prevent that from happening. So maybe it's not a state apparatus that is going to use that information about the relationship as a way of putting guardianship in place, of putting supported, because these are systems of surveillance as well. You know, you can always gather data about how someone's making terrible decisions if you see them every day. And there's this group of people who support that argument, right? But the state could intervene in responsible ways that protect the individual without depriving them of rights. So for instance, the protection and advocacy system, which is a separate entity funded federally that is there to prevent these abuses of power. So two possibilities given the system that we're in.
We are out of time now. I want to mention very briefly that there's CLE credit sign-up sheets, I believe, over there. And otherwise, just to ask everyone to join me in thanking our speakers. Thank you. You're here, so. Thank you so much. Such a great job organizing.